Good afternoon, everyone, and thank you for coming to today's CCPL seminar. It brings me great pleasure to welcome back Professor Paul Roberts. Professor Roberts is Professor of Criminal Jurisprudence at Nottingham Law School. He's also a regular teacher in Australia and also in the mainland. And many of you will know that he is the lead author of perhaps the UK's leading work on criminal evidence, Roberts and Zuckerman, now in its second edition, soon to be third. And we're also very pleased to say that his most recent co-edited work is this book here that I have in my hand, The Integrity of Criminal Process. And as I say, very pleased that the Hong Kong U colleagues have contributed to many of the chapters in this work. Professor Roberts is one of the rare evidence scholars who engages the law of evidence on basically three levels, right? The level of doctrine, right? What is the law? The level of, what is the reasons for the law, the rationales, as articulated usually by judges or law reform agencies. But more importantly, the third level, which sometimes or rarely do we often go there, is the philosophical underpinnings of the law of evidence. And I think in today's presentation, you'll see the importance of exploring not only the surface, but going deeper and looking at the foundations of the law of evidence. Professor Roberts.
Well, thanks very much, Simon. A very warm welcome, and hello to everybody. Thanks for coming along this lunchtime. So, I'm going to get up and walk around, as is my wont. Is that working okay? Yes. It's a bit echoey, I think. So, okay. Is that working as well? Okay. Sorry. Yeah? All good. Thank you very much. So, this is not so much a paper as an explanation of a program of work that I've been involved in, well, certainly over the last 10 years. There are various ways of describing it. One way of describing it would be a conversation that I've been having with William Twining over a long period about, well, just that, thinking about evidence and proof. Over 10 years ago, I wrote a paper called Rethinking the Law of Evidence, which was a Current Legal Problems lecture, which was in part in conversation with William Twining, and he was actually there when I gave the paper. It was very exciting for me to meet him and to be able to discuss that. And this is a kind of update, this is kind of part two to Rethinking the Law of Evidence that I published some time ago. And already, you should be able to see one difference. Before, rethinking the law of evidence. But now, no mention of law. This is a clue as to what is coming. Also, some of what I've got to talk about today is about thinking as noun, as other people's thinking, right? I'm talking about that. But really, I'm more interested about thinking as verb. I want you to be thinking about evidence and proof. And by the end of today's presentation, I hope we'll have time for discussion and questions as well. Perhaps you'll be thinking more about evidence and proof, and perhaps possibly even thinking a little bit differently. So that's my ambition. So one of William Twining's catchphrases is taking facts seriously. William published a number of papers over a period of time about taking facts seriously, and more specifically, how law and law teaching in particular fail to do so. So you see part one of my presentation, law of evidence, not taking facts seriously, not taking facts seriously enough. Just to remind you of a few things, it's a bit insubordinate to be saying these things in a law school, but I think that the charge sheet that I've put up here would apply to LLB-style degrees in the common law world, and we're all guilty of this, so I'm not standing here preaching at you about how we do things differently in Nottingham. We're just as bad. Just to remind you of a few things you already know. Most of our law degrees concentrate on the substantive law, right? You do classes in contracts and torts and criminal law and so forth. Procedural topics tend to be a minor component in law degrees. Now, you need to inform me here, is evidence a compulsory subject in Hong Kong? Is evidence a compulsory subject? Okay, right, okay, I see. So, most of you, I guess, will have studied evidence already or are going to do as part of your law degree. This is a very enlightened position. In the UK, evidence is not a compulsory subject as part of the LLB. And not only is it not formally a compulsory subject, but in fact, most students don't do it. I would say that possibly about 20% of our graduating class have taken a class in law of evidence from Nottingham. And that would be typical across the UK. So the vast majority of law graduates with an LLB did not study evidence as a part of their undergraduate degree. The only exceptions to this is Northern Ireland. For reasons that I don't know, but it just is a fact that in Northern Ireland, evidence is a compulsory subject as part of the LLB degree. It just is. But everywhere else in the UK, it's an option, and most students don't take it. Now, of course, they have to learn about procedural law as part of the bar exam and so forth. But, you know, I'm a bit ambivalent about that because Simon very kindly adverted to my own approaches to teaching the law of evidence, strongly grounded in theoretical rationales and the deeper normative frameworks of evidence law. I don't think they're getting that at bar school. You know, they're basically getting, these are the rules, learn them, reproduce them. So, okay, there is, of course, instruction in evidence law in England and Wales, but it's not the kind of instruction that one would hope to give to, in a law degree to undergraduates and postgraduates. So, point number one then, most of our law degree is about substantive law. Procedure hardly gets a look in. We also know that most of what we actually do in law school is study the decisions of appellate courts. We spend all our time reading reported judgments, learning how to interpret those materials and to distinguish cases and figure out what the ratio is and so on and so on. All of that we know. That's not what most legal practice looks like. Of course, if you're lucky and successful, you might get to do appellate court work after a while, you know, and do the high-profile cases. But the vast majority of legal practice is at the first instance level, right? Now, most law students are not exposed to those materials. Partly, certainly it's true in England and Wales, I guess true in Hong Kong just the same. It's actually very difficult to get access to the transcripts of first instance proceedings, yes? They're not reported in a formal way. They're law reports. You can get hold of them, but they're expensive and they're not easy to get hold of. So law students don't study trial materials. They just focus on appellate materials. If you take those two first points together, the focus again is on legal doctrine at the appellate court level. We're basically not talking about facts. You know, we're not taking facts seriously. And the most striking illustration of this is the way that we set exam papers in substantive topics. How often have you encountered or used yourself in a criminal law problem or a torts problem? You say, don't worry about the facts. These are the facts. I'll just tell you what the facts are. These are the facts. Now you apply the law to those facts as given. We don't even think about issues of fact-finding and fact analysis. It's just taken as read. Again, legal practice doesn't work like that. Not only in practice are people mostly concerned with first instance rather than process, they're also mainly concerned with facts, not with law. Yes, again, it's true that occasionally you might get a case that raises a really meaty point of law that you can argue in court and have fun with. But most practice is not like that, certainly not in criminal law. It's mostly about the evidence. It's mostly about managing facts, analysing facts, presenting evidence, taking facts seriously. You can see the picture I'm building up here, and it's really Twining's picture that I'm just repeating, that the way we do legal education is a long way removed from the realities of practice, and in particular, for our purposes, what we're not doing is taking facts seriously in law schools. Final 2 points are just elaborations of this. I mentioned first instance trials, but we can take that thought further, because actually most practice is not trials. Whether you're talking about civil matters or criminal matters, most cases settle or plead. A trial is a rarity, case that goes to trial. Most litigation is about avoiding trials. So when we think about fact management in the litigation process, and in our minds we immediately think of the courtroom, don't we? Everybody does. Lawyers and non-lawyers alike. They think about Hollywood images of lawyers in court. But again, that's not actually where facts are mostly managed in litigation. Facts are managed in the prosecutor's office, or in the police station, or in the forensic scientist's laboratory. That's where fact management goes on. But again, we never talk about that in law school. We never think about those processes. Just because you're not in court doesn't mean you're not thinking about it. What do the police do in the station when they interview suspects? They are generating evidence. What's a forensic scientist doing in the laboratory or a scene of crime examination? They are creating evidence, generating facts to prove in court. Or not in court if it settles. So, when we think about taking facts seriously, we mean throughout the entire process of litigation. And I will myself talk about criminal law because that's my interest. I'll talk about criminal litigation. But most of the points that I'm going to be discussing today apply more or less, mutatis mutandis, to civil litigation as well. It's just that I tend to think about criminal law examples. And then finally, topics that you might think any reasonably well-educated person would have a sound grasp of. Statistics, probabilities, basic logic. Not taught in law schools. Some of these topics might sound somewhat intellectual and rarefied, but let me assure you that if you're a criminal practitioner today, you absolutely have to get to grips with these kind of ideas. How are you going to present DNA evidence to a court unless you can understand probability and statistics? You can't do it. So what I'm talking about here, yes, it has a theoretical dimension, but it's absolutely practical. Taking facts seriously is about the practice of law as well as legal education. It's something so what I've got to say today ought to be of no less interest to practitioners as to law students and academics. Okay, so I'll go a little bit quicker now. Just some quotations, just rather nice Twining's turn of phrase here, some sort of memorable turns of phrase. You can read it for yourself. Twining said, the subject of evidence is typically treated as being coextensive with the law of evidence. I've already warned you about that conflation. Topics such as probability covered. Evidence doctrine has yet to be put in its proper place as just one part of the science of proof, the science of proof. At the moment, it's treated as a satellite of the law of evidences. That's rather like treating London as though, England as though it was a suburb of London. He says it's completely the wrong way around. We spend all this time thinking about the doctrine, but it's the facts that we should be thinking about. Not instead. I'm not saying doctrine is not important. Simon kindly mentioned our book. It's full of legal doctrine. It's important, but it's not the only thing that there is. It's possibly not even the most important thing. Twining wrote those articles originally in the 1980s. The argument wasn't new for him either. In fact, the same arguments were at least 100 years old in the literature. If you go back to the scholars who can be regarded as, certainly in US terms, as the sort of fathers of the evidence as a university subject, I'm referring to Thayer and Wigmore at the turn of the 20th century, they were making these kind of points. So Twining, Roberts was repeating Twining, but Twining was just repeating Thayer and Wigmore to a large extent. It's a very famous quotation. If you don't know this already, you should memorize this. It's a good one for exams. I'm sticking a few quotes here. The law furnishes no test of relevancy. For this, it refers to logic and general experience. It assumes that the principles of reasoning are known to its judges and ministers, just as a vast multitude of other things are assumed to be known. Here's the quote, here's the one for the exam. To the hungry furnace of the reasoning faculty, the law of evidence is but a stoker. The law of evidence is just the ancillary part. They are saying what's really important is facts and reasoning about facts. Now, this is the same insight. Unfortunately, it just is the case that, certainly in the US and in England too, the way that this observation has been treated subsequently is not that we should therefore investigate further these principles of reasoning, take facts seriously, but because the law furnishes no test of relevancy, therefore we can just forget about it and not talk about it at all. So, standardly, in books on the law of evidence, they start off with one of the first chapters will be about basic concepts and talk about relevance. And you'll get the test for relevance, and this is the leading case in England. I guess you know this in Hong Kong as well. It's probably cited. There are probably local variants as well. To be relevant, says Lord Stay in the House of Lords, the evidence need merely have some tendency in logic and common sense to advance the proposition and issue. So all law students who take the law of evidence, which is a minority of them, as I explained, but if they take the law of evidence, they learn the test for relevance is logic and common sense, and I have them all citing this, and they learn this by rote. The problem, though, is that once they've done that, the tendency is just to forget about it, and then go and talk about 14 exceptions to the hearsay rule and 100 cases on bad character, etc., etc. They haven't learned the lesson. Some tendency in logic and common sense. That's not an excuse to forget about those things. It's an invitation. Because your next question should have been, what do you mean by logic? And what do you mean by common sense? And that's the moment when we start to take facts seriously, when we start to think about evidence and proof as the science of inferential reasoning. Yes? And it's those kind of thoughts that I want to develop in this presentation. It's what some of my work's been devoted to over the last 10 years or so. So, last bits of Twining. Says, referring to that quotation from Thayer, that it's almost as though the law, the way you think about evidence, is kind of like a Gruyere cheese, you know, the cheese with lots of big holes in it. The cheese is the rules of evidence. And we have all these rules about hearsay and bad character and burden and standard of proof and all of those rules that we all learn. But all the gaps in the cheese are missing. Or, he says, it's like the Cheshire Cat in Alice in Wonderland. You might see a head or a bit of a body, but it keeps disappearing. Now, when I first read these quotations, I thought that was a very striking image and a very nice image. But it's only really subsequently that I've really kind of understood just how right Twining was about these points. Because I think, this is something I've come to, the view that I've formed, that actually it's not just that if you don't talk about the logic of inferential reasoning, taking facts seriously, it's not just that you miss out all the holes in the cheese and forget about those things, the logic and the common sense. It's more than that. It's actually you won't understand the doctrine properly either. And this is something now that I really emphasize to my own students in evidence, that you won't make sense of the law of hearsay unless you understand the logic of inferential reasoning that underpins those rules. You won't make sense of bad character evidence unless you can think about the inferential process of treating extraneous misconduct as a basis for drawing other inferences. And a whole lot of what's wrong with evidence as a subject and the way that it's taught is that it too often disintegrates into a long list of rules and cases. And evidence gets taught then, gets consumed by students as though it's just a kind of horribly complex memory game. You know, and you say, well, here's another rule, and here's another rule, and here's another rule, and here's another rule, and here's another case. And there's always another case. Section 78 of the Police and Criminal Evidence Act, 1984, is the English unfairness exclusionary rule. It's a general rule that says if evidence is so unfair that it shouldn't be admitted, it can be excluded by the judge. As common lawyers used to say, as a matter of discretion, and that's problematic. As I tell my students right at the beginning of the course, if you go on Westlaw, there are more than 1,000 cases on Section 78. More than 1,000 just on that one section. What are you going to do? You're going to read all those cases? No one's read them all. Court of Appeal hasn't read them all. What, if you spent the next year of your life reading them all, what would you learn? What you'd learn is, here's another case, here's another case, here's another case, here's another set of facts. What we really need to understand is the deep structure of that jurisprudence. Now, we already do that to a certain extent insofar as doctrine is concerned. We try and learn the general principles. What I'm trying to do here is extend that same kind of argument and reasoning to not the law, but the facts. The idea that we can get more serious about the principles of factual inference. So I couldn't resist a few pictures. There's the cheese, and there's the Cheshire Cat, in case you don't know. Those images. Without the facts, the law is only half the story. Okay, so let me say a little bit more in terms of background and intellectual history to the sorts of things that I'm interested in. And then in the third part of the talk, I'm going to give some practical examples of all of this. So, here's Mike Pardo with another resonant quote. The trial is fundamentally an epistemological event. Epistemology, the science of fact-finding, science of knowledge. Epistemology answers the question, how do you know? Now, I think Mike's wrong about that. Because if you ask me, I think the trial is fundamentally a justice event, not fundamentally an epistemological event. Because, as we all actually know, if you think about it, fact-finding in litigation is constrained by normative rationales and principles. In law, fact-finding, the search for truth, if you like, put it that way, serves justice, not the other way around. So in terms of the order of priorities, justice is the first consideration. But if you come from a tradition of treating the federal rules of evidence, it's very easy to think that it is primarily epistemic. And I'm not denying that epistemology is an important part. So I think Mike's overstated his case there, but in a good cause. Because I agree with him to the extent that well, as Susan Hart says somewhere, law is up to its neck in epistemology. That is to say, in litigation, fact-finding, truth and proof are obviously key considerations for us. So we don't have to quite go so far as to say that it's fundamentally about epistemology. We certainly say that that's a fundamental part of what law and adjudication are all about. Whether or not we formally acknowledge it, law is committed to a rationalist epistemology. That is to say, we think that there is some connection between evidence and proof. Now, you have to be careful here, because, you know, trial lawyers, particularly if you get a little bit cynical in your older age, we all do, you know, they say things like, oh, a trial is a lottery. We just roll the dice. We go to trial and roll the dice. So it doesn't matter, you know. Anything could happen at trial. That gives a pretty misleading message about what's really going on in adjudication, because we are, at a very fundamental level, committed to the idea that in general, and that's very important, in general, the side with the best claim will have the best evidence. That's the fundamental rationalist claim. Again, as lawyers, we get confused about this, because, you know, if you work on, say, miscarriages of justice, you know all the statistics about the fact that, well, I'll ask you, do you know what the single biggest cause of wrongful convictions is, as far as we know? All the work that's been done in this in the US and elsewhere. Do you know what causes miscarriages of justice? The single biggest contributing factor? Thank you very much, Janet. Wrongful identification evidence. Eyewitnesses who get it wrong. That's the biggest. Second, forensic science. From the appellate perspective, and thinking about miscarriages of justice, you get it into your head that these are dangerous forms of evidence. But in many ways, that's kind of back to front. Think about how many cases, day in, day out, rely on eyewitness testimony. Or how many cases, day in, day out, rely on forensic science of one kind or another. See, here's the thing you have to get your head around. It is simultaneously true that these are the best forms of evidence, and they sometimes go wrong. The rationalist claim is that, in general, the best evidence demonstrates the best claims, not that it never goes wrong. And again, I think as lawyers, because we're looking at appellate cases, as Dworkin pointed out as well, you know, we spend our time on legal pathology. An appellate case is a case in which something went badly wrong and it went on appeal. Most law is not like that. In the routine case, cases are not tried. If they're tried, they're not appealed. So, same with evidence. Even though all kinds of evidence are fallible, even though sometimes eyewitnesses are mistaken, even though sometimes forensic science gets it wrong, in general, these are cogent and sometimes compelling forms of proof. And again, as I said, as a general proposition, the side with the best evidence will tend to be the side with the best claim. Now, and here's the thing, to repeat, that better be true. That better be true. Because otherwise, a trial is just a lottery. If there were no rational connection between evidence and proof, the whole thing is a charade. It's just a series of storytelling. You might as well, you know, it's just competing narratives or something like that. So it leads to a deep and corrosive relativism to deny this kind of rationalism. So we need to be clear, because the rationalist claim is not that evidence is always reliable, or that the party with the best case always wins. It's simply that, in general and over the long run, they generally do. This point about the significance of fact-finding in the rationalist tradition could not be more important. It could not be more important. Ron Allen brings us out in this quotation. Again, as lawyers, we tend to think about the importance of rights, substantive rights, maybe even constitutional rights or human rights. None of that means anything unless you have sound procedures. None of it means anything unless you've got access to justice. You know, it's a notorious fact about the 20th century's worst authoritarian regimes that they all had perfect systems of rights. Oh, well, not all of them, but a lot of them do and did. Those rights are themselves meaningless if they can't be enforced. And crucially, you can't enforce them unless you can get evidence. Unless we can rely on the rationalism of reasoning about facts to get from evidence to proof, then human rights, constitutional rights, the rule of law, it's all gone. So here's another fundamental point. Generally, as lawyers in practice or in education, we tend to think that procedure is the handmaiden of substance. You know, you start with the rights and the procedures are subsidiary. We think that way. Bentham's partly to blame because of the very language. Substantive law is Bentham. Adjectival law. Well, of course, you know, the analogy to syntax is that what's really important is the substance. The adjective is just secondary. What I'm doing here is reversing that. What Ron's doing there is reversing that. Saying that actually, in practice, in practical terms, the procedure is more important than the substance. Because it doesn't matter what paper rights you've got, if you can't enforce them. You can't get access to law. If you can't have the resources to make a good defence. And crucially, again, to repeat, if you cannot demonstrate the rational connection between evidence and proof. I'll put it the other way around. In criminal law, of course, the demand is on the prosecution, on the state, to demonstrate, not just with a good story, that the accused is guilty, but with evidence. Evidence that rationally demonstrates that the accused is, in fact, guilty as charged to the appropriate criminal standard, which, as we know, generally in the common law world is beyond reasonable doubt. You may or may not know that we don't use that in England anymore. Here's a kind of something else to stick in your essay as a piece of comparative information. We've actually stopped using beyond reasonable doubt in England and Wales. There's a whole story behind that. But juries are now actually directed in England and Wales that they need to be sure that the accused is guilty on the evidence. And they are directed that if they are sure, they can convict, but if they are anything other than sure, they should acquit. The judge doesn't use the phrase beyond reasonable doubt. The only exception is if the jury, after deliberating, comes back to the judge in court and says, "Judge, we're a bit confused because you've told us we need to be sure, but what about this beyond reasonable doubt we all know about?" Because we've heard it on, you know, it's just a cultural phrase and we've seen it on the Hollywood movies. But English law's quite cleverly sorted this out as well, because at this point, the judge is just to say to the jurors who are confused, "Don't worry, it's the same thing, go away." What they must never do is try and define beyond reasonable doubt, because we have a century of trying to define beyond reasonable doubt, and it never works. You don't define it. As I say, in England, we've even stopped using it. The point, though, is that there's a high threshold of proof. It's required in criminal law, and that, as much as the Human Rights Act, the Bill of Rights, whatever it might be, that guarantee that the state must prove it with evidence is as much your guarantee of freedom and the rule of law as anything else. All of this is working up to the question, how do we do this thing? So it's all very well talking about taking facts seriously. I've used these phrases like the logic of inferential reasoning, which sounds fancy. It's a useful encapsulation of what I'm talking about. It's the science of proof. How is it? How do we do it? Part of the enigma here is that it's something we do every day, all the time. We don't particularly instruct jurors about how they should go about fact-finding. We just put them in court and tell them to get on with it. We don't give them a course in epistemology. So there's I'm careful about the word paradox, because philosophers use paradox in a very technical sense, but there's almost a paradox here, in that it's logic and common sense. What else do you need to know? Go away and do it. And yet, there can be this science. The fact that we do it every day, and it comes, if you like, natural to us, doesn't mean there's nothing to investigate. Doesn't mean that by reflecting on our naturalistic process of inferential reasoning, doesn't mean that we won't understand more and maybe even get better at doing it by systematically reflecting on inferential reasoning. So my topic then, the science of proof, is simultaneously commonplace and everyday and a kind of mystery. That's the paradox. I hope to have persuaded you in the next half an hour that I've got left or so that there is something more to be said and worth talking about here. Just so you can see, I don't only cite myself. A good starting point when we think about evidence is just to say that it's really just information. And that's already a quite interesting move at that point. Because when we say evidence, particularly in this context, we already think of something quite specialised and refined. Judicial evidence, or in the literal way, forensic evidence. Forensic meaning pertaining to law, not science. So forensic in general is just legal evidence. And that already gives evidence a kind of specialist meaning. But we need to strip that away a little bit and go back to basics. Logic and common sense, remember. If we do that, it's evidence, it's information, it's data. That's all it is. If we start with that, we immediately make links to the uses of evidence in other contexts. Doctors use evidence, historians use evidence, journalists use evidence. Are we doing the same thing as them in law, or something different? Not to give the plot away, I'm going to say right up front that the answer to those questions is up to a point. Up to a point, we are doing the same things in law as they do in journalism or politics or history or forensic science or wherever it might be. Dealing with information, dealing with data. The difference is we're doing it in a particular specialist normative context. So there are differences about judicial evidence, but there is much that is shared. Why? Because we're all human beings. And to the extent that what we're talking about is the human capacity for drawing inferences from data, it applies to all contexts when humans do that. So we can learn from the psychologists, from the computer scientists, from the artificial intelligence people, from people who do physics, from people who do methodologies. We can learn about these processes of inferential reasoning. So another aspect of this then is evidence, not as a specifically legal subject, but as a thoroughly interdisciplinary enterprise. The science of evidence is only partly about law and lawyers, and encompasses many other things as well. And these are two-way streets. Some of the way that we handle information in law, we can teach others about that. You know, we've developed processes in law for handling information and testing it. And that can be something we can share with other people. But at the same time, we learn from them, possibly about better techniques for dealing with evidence and proof in a legal context. And already, just in that 3 words there, evidence is information. Immediately, if we think about that, it opens up these possibilities to a thoroughly interdisciplinary science of evidence. And relatively recent book, trying to explore these themes. There's a quote in the introduction there from Phil David, read it for yourself. Basically saying, I'll just summarize, that for us today, data management is one of the biggest challenges we face in our societies. I can't remember the precise statistic here, so I'm just going to make it up, but you get the drift. It's something like half of all the information that humans have ever generated was generated last year. So half of all the information in recorded human history was generated last year. That exponential development of data. It's mind-blowing, mind-boggling. If you think about open CCTV, recording digital images, millions and millions and millions of images a day, this stuff being stored somewhere. I mean, we know they're all watching us. They're watching us, right? But who's actually analysing this stuff? How are you even going to have an algorithm review this material? So, as a general matter, data management in a context where data has exploded, or have exploded, plural data have exploded, is one of the great challenges we face in our modern societies. And that will necessarily have impacts on law. And just one example of that is the use of digital forensics. Just a footnote here, just one concrete example to concretize this for you. You must know, I guess everybody knows now, that your mobile phone is basically a personal tracking device, right? Now, it turns out that many people who commit criminal offences are not too bright and haven't figured this out. So, these people committing burglaries and criminal damage and so forth, with their phones switched on, police are able to say, it was you on that day, at that place, and here's the proof. Now, we've gone from a position where, say 5 years ago, it would have been very rare to get that kind of mobile phone evidence in a criminal trial in England and Wales. Now, it's every other case using this. That's just one example of a completely new technology that is... and that's right on cue. David Feldman in Cambridge has got a good line for this, a very good line. He always says, if that's for me, tell them I'm busy. Okay. Well, that's one example of a completely new technology that has immediate practical forensic applications in criminal proceedings as an example of data explosion. You can multiply those examples. And these are real-world examples with real-world practical consequences, although I'm a kind of theorist and I use words like epistemology, I keep emphasising that this is going on in court day in, day out. So, that's all been built up, really. The first part was telling you about my own intellectual journey and how I went into this. The second bit was a little bit of broader intellectual history about people who've discussed this previously in legal work, and I explained how, in many ways, Thayer spotted the issue, and then we all forgot about it for 100 years. Well, we're trying to remember again now. Now coming on to more practical illustrations, something to get your teeth into a little bit more. The one exception to what I've just said was John Henry Wigmore, Thayer's disciple. Wigmore was active in the 1920s and 1930s in the US, leading constitutional law scholar as well, and a comparative lawyer as well as an evidence lawyer. Now, there's a rather nice vignette here, because Wigmore is possibly the most cited scholar in US jurisprudence. If you do a Westlaw search for Wigmore, you'll get thousands and thousands of references. Their references are basically to his treatise. He wrote this huge, huge book. It's in about 12 volumes on the law of evidence of the US. And it goes through all the common law. It's before the Federal Rules of Evidence, obviously, it came in 1975. So Thayer produced this massive work on the law of evidence. And that became the Bible for the law of evidence in the US. And it's cited and cited and cited. And even though now it's been superseded by the federal rules, Wigmore is still cited for general principles. Well, that was one famous book he wrote. He also wrote another book. And that other book was about the logic of inferential reasoning. And Wigmore even set out a method for doing it. So he had these two bits. He had the doctrine in the 11 volumes, and he had the book on the science of proof. And the book on doctrine became incredibly famous and has been cited thousands of times. And the book on inferential reasoning, well, you can't get a copy. It did go editions. The last edition was in 1937. And it's hardly much of an exaggeration to say that, with the exception of two people, that's William Twining in England and Peter Tillers in the US, nobody read that other book for 70 years, 60 years. The one about inferential reasoning. Lawyers forgot about the science of proof. They only cared about the doctrine. They wanted 2 volumes on exceptions to the hearsay rule, but they weren't interested in the science of proof. Well, part of this project is about reviving Wigmore. It's about back to the future in that sense. Again, I'm not saying these are new arguments, but they're arguments newly made because we all forgot about the arguments. 1913, Wigmore set out what is effectively a manifesto for a science of evidence. I'll read this one because this is really important. Wigmore says, there is, and there must be, a probative science, that is the science of proof. The principles of proof, and they are independent of the artificial rules of procedure. He's not being pejorative there by saying that rules of procedure are artificial. It's just that they're positive law, right? Codes of criminal procedure, they vary from country to country. It's human-made law, positive law. He's saying there's artificial reasoning, procedure, but then there's natural reasoning and procedure as well. Procedures of thought and inferential reasoning, and it's that thing that he wants to get back to. This science may as yet be imperfectly formulated, or possibly even incapable of full formulation. So 100 years ago it was incomplete. Today it's still incomplete. All the more need is there to begin in earnest to investigate and develop it. Well, you didn't. Procedural rules for admissibility are merely a preliminary aid to the main activity, viz. The persuasion of the tribunal's mind to a correct conclusion by safe materials, or in other words, persuading the jury with good evidence. That's what he's talking about. This is the main process. That is the fact-finding process. This is the main process for which the jury are there, and it's on that counsel focuses their duty. If you're a trial lawyer, your main audience is the jury. Or if it's a judge, the fact-finders is the judge. Vital as it is, he says, its principles surely demand study. And, you know, that has to be right, I think. One of the interesting things about this to me is it took me probably 10 years to really figure out that that's right. I'd read all this stuff, but not really taken it seriously myself. And I think, in that respect, you know, Twining persuaded me in the end. Now, this is one example that Wigmore himself gives of his method for mapping out inferential relations in a case. And what do you think when you see that?
Actually, most people reading Wigmore stop.
Correct. They see that and they go, oh no. You know, it's kind of like some crazy hieroglyphics, and in order to do this, I'm going to have to learn this strange language of Wigmorian analysis, which will probably take me years to learn. Well, you know, if I'm a lawyer or if I'm a law professor teaching law, life's too short, right? I've got stuff to do. You're not going to learn this. As Janet rightly says, that's about as far as most people get. Most people have never heard of it. Of that number who have heard of it, that's as far as they get. Because Wigmore's own system of graphical representation of inferential reasons is hideously complex. But here's the thing, it is gratuitously, hideously complex. What you see there is a reflection of a particular personality type. And I'm not a psychologist, but psychologists could tell you stuff about people who draw charts like that. Okay? Cut to the chase, the reality is that you only need about 6 or 7 symbols to do this. And it's really easy to learn. And for the last 5 years, I've actually been teaching this. And I can tell you that I can teach people to do this. And I taught myself to do it. Well, William partly taught me, I taught myself. So it's actually easy. The only question worthwhile, and we'll come to that in a minute, but we know from the history of things like Esperanto that if you create a totally artificial language that no one needs and no one uses, it'll die off. And it turns out English is just easier. What we're doing then is not reviving Wigmore in its entirety. We're not reviving Wigmore's own system. William talks about modified Wigmorean analysis. And you don't need to use that phrase. What we're talking about is a very much stripped-down version. The basic thought is that some kind of graphical representation is actually a very efficient and effective way of representing complex relations. And we do this in all kinds of contexts. I mean, if you think about, if you've been to London, you see the iconic map of the London Underground, yeah? With all the different coloured lines. That is not a topographical representation of London. If you try to walk around London with that, you just get lost. It's a symbolic representation for a particular purpose, yeah? That's just one example of the way that we use images. We use graphical representations as a way of clarifying and simplifying and rendering manageable material that would just be too big or too complex otherwise. So, data, that's not quite right because stuff is out there and we make them data by taking an interest in them and collecting them. So data, information, evidence is actually already the result of a process. If you're a crime scene examiner, the information doesn't just jump out and fall into your pocket. You go and look for stuff. If you're a lawyer or a police officer interviewing a suspect, you're looking for things. Why do police officers say to suspects, so then, when you took that thing, what was going through your mind? That's what they do in England. Why are they asking them that? Because they know they've got to prove dishonesty. They need the mens rea. They need proof of mens rea. Proof of mens rea doesn't just jump out and hit you in the face. You go looking for it. So data are a product. What's out there is the dots, the potential data. And putting together a legal case, it's a puzzle of join the dots, connect the dots. The thing is that the dots can be connected in literally any way. You can tell an infinite number of different stories with the data. Now, that's not a problem with the Wigmorian method. That's a fact about information. So, what we start to see is just how amazing it is that human beings are able to process the information that they're able to process and to act on it, when we are constantly bombarded by different stimuli. And one of the ways you see this is in people who work in artificial intelligence, trying to make computers think like human beings. Incredibly difficult. Incredibly difficult. I know they've now got the chess machine that can beat the grandmasters, right? But it's taken a long time. Taken a long time to get a computer to beat a human reasoner. Think about that. Your phone is 1,000,000 times better at maths than you are. If it was simply a question of computation, the computer would win every time. So it cannot simply be a problem of computation. It has to be a problem of analysis and sense-making. And the way that they've made the computer beat the grandmaster is to make the computer mimic the human reasoning processes. Psychologists talk about the use of heuristics. This is what we do. Heuristics are mental shortcuts. They enable us to cope with the world. You know, if you're a computer and you saw a large object coming on the road towards you, saying, you know, well, that could be one of a billion things. Let me now go through my checklist. You know, is it a horse? No. Is it a cow? No. You know, a human being will go, it's a bus, get out of the way. That's it. We have a heuristic that allows us to make those mental shortcuts. That's how we deal with information processing. Incredibly difficult to mimic that in computers. So now we're starting to investigate that paradox a little bit more, because I said that inferential reasoning is just a matter of common sense. It's something we all do every day. It's actually, though, amazing that we do it every day. The science of evidence is an attempt to investigate that further and to try and systematize it a little bit. So, here's an actual example of the power of graphical representation. This is a relationship chart of a number of individuals who were connected to what we call in England the 7/7 bombers. These were the people that tried to blow up Finsbury Park. Each one of the lines is a connection of someone making a phone call or connecting to somebody. But what's amazing is, you don't need to read all the names. The green dot in the middle, that's Sadiq Khan, who was one of the main plotters. Visually, look at where it all centred. Finsbury Park Mosque, and right there, in the middle, green dot is one of the key bombers. You get the point. Visually, you can see this immediately through a map of relationships. So, Wigmore charts are that kind of map. They're a way of encapsulating all this information in a useful instrument that we can then use for practical purposes. Okay, that's just a little joke, slightly unfair observation about the failure of the security services to figure out how to connect the dots properly. You do have to be wary here of what the Americans call Monday morning quarterbacking. It's just a version of, in hindsight, all looks so obvious. You know, in hindsight, the fact that the 9/11 bombers weren't interested in learning to land, that should have been a clue. Now, it would be. But of course, no one had seen it previously. Actually, the security service had already modelled using planes as bombs, so they actually did know. But most people didn't know. Most people could never have imagined that a terrorist attack might be conducted in that fashion. Now, if you're a flying instructor and someone comes along to you and says, I only want to learn to take off, you know, you need to be calling the police. We all know now. So in hindsight, it's so obvious. In hindsight, it's obvious how you connect the dots. But the problem for much litigation and for case preparation, the problem is we're doing it ex ante. We don't know the answer. In litigation, the facts are contested. We don't know. It makes the problem all the harder. What you need is some kind of magnet, some way of pulling out the dots you want. Marshalling evidence, that's the way that Dave Shum refers to it. Marshalling evidence points, saying these are the particular ones we're interested in, and they fit together like this. Another metaphor, I know I'm using quite a few, but another one would be that Wigmore charts are like a kind of magnet for facts. It's a way of sticking them together in a particular way that is especially salient for a particular case that we might be working on, a particular police investigation, whatever it is. So, slight formalism here before I give some examples. Just go through the principles here. Rationalism is just another version of, well, it's a formalization of the rational tradition in evidence, scholarship, and proof. Namely, that there is a rational structure to these things. It's not just completely random. The dots are not connected any old how. They're connected in a particular way. Furthermore, second, I've called this cognitivism, there's something to know. Remember in Wigmore's quotation from 1913, he said, perhaps the science of proof will never be known. And that might be true. It may be that in the final analysis, human inferential reasoning is a kind of mystery. Now, you might have got religious views about that or whatever. There are various versions you can go down there. My claim, and Wigmore's claim, is not that we can understand everything about human inferential reasoning. Computers help us. You know, we're learning more and more as we go along. Disciplines like cognitive psychology are becoming more sophisticated. So we're learning as we go. The only claim is we can find out some things. We might not be able to find out everything about how human beings do this, but we can find out some things and we can put those things to good use. Three, I mentioned this already, understanding is not just a cognitive but also a practical activity. So if you analogize this to other types of practical skill, so I mentioned two. One would be learning to play a musical instrument. Another one would be learning to drive. Okay? Now, at some level, you can just pick up an instrument and have a go. And if you've got some talent, sooner or later, you know, you'll get a note out of it or a chord or you'll figure it out. Equally with driving. You could just get behind the wheel and have a go. I'm not recommending that on the public roads, certainly not in Hong Kong or even in Nottingham, come to that. But you could. You know, farmers' kids getting into tractors on the field and just have a go. You can do that. However, most people learn in part through some kind of cognitive or theoretical process. So when I learned to drive, and I learned to drive relatively late in life, I was in my 20s, the instructor breaks it down for you. You know, first of all, you put your foot on the pedal like this, then you put your hand on the gear stick, and and you do it in a series of stages. Same with learning a musical instrument. When you become more proficient, you do it, almost feels like by instinct. Now, if you're a good driver, you don't think about driving, you just do it. You don't think about driving any more than you think about speaking, walking. You just do it. The point here is that the same idea can apply to inferential reasoning. We already do it, but if we theorize what we're doing, have a think about it, and try and formalize it, there's a decent chance we'll get better at it. And that's the claim, that doing something like modified Wigmorean analysis will actually make us better at the things we already do. Number four, symbolic formalism. This is just a point I've made already. It's partly a personal thing. You know, you just know yourself. Some people are good with numbers and some people are better with words. And it's just a kind of personal psychology thing. Some people like graphs and charts, other people not so keen. There is a personal element to this. All I will say is that for most people, some value is to be had out of symbolic graphical representation. It's different and in some ways better than just narrative writing, prose. For some people, they much prefer it, and it's very interesting to watch students. Some students really take to this. I've literally had students say to me, I will never do another intellectual task in the same way. I will always use the system. For every essay, for every case I look at, I'm a total Wigmorean now. They really buy into it. And you can use it in that way. Most people, I'm like this too, are moderate advocates when they get to use it. They think, yeah, it's a good thing. It can work sometimes. It can be useful. It's not going to change my whole life, but it's a useful set of techniques, not least of all in law, in litigation. And then there will be some people who just don't get on with it. And it is a personal thing at the end of the day. But again, I say to you that for most people, something like this is useful, beneficial, and can be learned in a relatively short space of time. And then the Wigmorean point is that we can use this specifically in a legal context using a modified graphical notation. So I'm aware I'm going to wrap it up in 5 or 10 minutes, so there'll be time for questions. But let me just give you some examples. I'll keep promising this. I'll run through that. These basically are all the symbols you need. The key idea is that you have propositions and you have inferential relations between propositions. Propositions are either round circles or squares if they're given in evidence. So the square box is just a particular kind of proposition. It's one given in testimonial evidence. The arrows are the inferential connections. That's the most basic form. Circles and arrows. You can jazz it up a little bit more with some of these extra things. I won't go into that now. That was produced by one of my students after 4 weeks. So that's just, I show this to everybody just to show you can do this. You can learn it. What you have at the top is what we still call, and what Wigmore called, the ultimate probandum. The ultimate probandum is the final proposition that you're trying to prove. The thing that must be proved is probandum. So your ultimate probandum is, for example, X murdered Y in a criminal case, or X breached contract C, something like that. All the other propositions and inferential relations are a marshalling of arguments and evidence leading to those propositions. So you end up with something like a tree or a pyramid, because every level you go down, you get more and more propositions. It gets more and more complicated. So that might be a chart for an entire case, or it could be just one issue within a case. So you can imagine a case in criminal law, for example, where most of the facts are agreed, but the issue is mens rea. Prosecution saying intention, the accused is saying no intention. In that case, you wouldn't necessarily chart the whole case, you just chart the mens rea propositions. So, very simple example, which I've used myself. That would be the top of the chart. You've got your P1 is your proposition 1, the murder case, A murdered V, and of course it can be for any legal issue. It doesn't have to be a criminal case, it can be any crime if it is a criminal case. The next row are the penultimate probanda. So not all the rows have got fancy names, but the top two have got fancy names. Ultimate probandum and then penultimate probandum. And you can see the relationship between propositions 2, 3, 4, 5, and 1. If 2, 3, 4, and 5 are true, they together authorise the inferential leap up to proposition number 1. So this is just standard stuff. All lawyers will recognise this. If it's true that V is dead, that's P2, and if A caused V's death, 3, and A killed V intentionally, 4, and A had no lawful justification or excuse for killing V, then A murdered V. Yes? That is just a version of what we all learn at law school. That's how you do criminal law problems. You break down the crime into the individual elements, and then you see that each one is satisfied. So what Wigmore charts are then are pictures of logic. They are pictures of logical inferential relations. Clearly, this is incredibly simple. It soon gets a lot more complex as you add in more facts and more evidence, but we get this basic idea of it. Now, there are lots and lots of benefits to doing this. I've kept saying to you it's useful, it's beneficial. I'm now making that claim more specific. There are lots of benefits, and I'm going to run through this fairly quickly now because I don't want to take up all the time. First benefit, you have to be really strict and careful about the formulation of your propositions. If you read down all of these propositions are all quite similar, but actually logically different. And forcing yourself to look very carefully at the specifics of a proposition is just good legal analysis. This kind of method helps you do that. The evidence proves that A murdered V is not the same as it proves it beyond reasonable doubt. It's not the same as saying admissible evidence proves it, etc., etc. These are all similar, but actually different propositions. Law students often will get confused about this stuff and make errors. They're errors of logic. You need to concentrate on the propositions. We also bring out the generalizations that we assume when we make inferential jumps. All inferential reasoning relies on a whole set of generalizations of different kinds. Often, typically, these generalizations are not articulated. They remain unspoken. They're assumed, but not spoken about. This means that they can be dangerous as well as necessary because they can trip you up in various kinds of ways. Wigmore charting brings out unspoken generalizations. I keep promising you I'll give examples, and I will. So, for example, if you take a very simple case of two propositions and one inferential link, the witness testified that P. Could be anything, doesn't matter. You know, I saw him do it, whatever. Ergo, the inferential leap is, therefore P. Witness testified P, therefore P. Is true is just strictly redundant in formal logic. P just means it is the case that P. Now, all the time when we think about witness evidence, this is the inferential structure that we're using. Witness says it, therefore we infer that it's true. But actually, what we're actually doing is something like this. This is now a piece of Wigmore charting, a bit more complex. You've got the original propositions, they're now 1 and 4. But all kinds of other propositions are involved in this inferential leap. I think 2 is very interesting, generalization. Generalization is what people say, or as the case may be, testify on oath, is usually truthful and accurate. Now, that generalization strikes most lawyers as dodgy because as lawyers we're used to not believing witnesses and cross-examining them and thinking that they might be lying or mistaken. But actually, as a matter of logic, you could not draw that inferential conclusion unless 2 were true. Already, Wigmorian style analysis is bringing out hidden assumptions in our arguments. You can then become much more sophisticated and think about the reasons why the inference to 4, that P, might be blocked. And basically, it's all stuff to do with what lawyers would call the credibility of the witness. But credibility breaks down into different ideas. And Wigmorian analysis helps us to do that. It helps us to specify what those particular problems with the witness evidence might be. So, what looked like that actually looks like that. This is us now taking facts seriously, using this kind of method. I'll give you one more example, and then I'll just conclude. Forensic science, which is an area that I work on quite a bit, for many forensic science disciplines, has the same logical structure. You can call comparison forensic science to cover a whole bunch of things that could be fingerprints, DNA, tool marks, soil, dentition, gait analysis, footprints. Basically where you're comparing something at the crime scene and a reference sample from the accused. And you're saying, do they match? Right? All the comparison forensic sciences operate using that logic. And basically, what we're trying to get to is 6, that this person committed the offence. In order to get there, we basically need to establish that they are, in fact, the source of the crime scene sample. If they are the source of the crime scene sample, that might authorise the further inference that they are guilty. Now, the reason that I've put those propositions in red is as a warning, because forensic scientists should never testify to 5 or 6, ever, but they do routinely. Any expert witness in a criminal case who says it's him has made a logical error already. This brings it out. The logical error is that even if the crime scene sample matches the suspect's reference sample, it doesn't mean he's the donor. It just means he's one of a subgroup of people who could have been the donor. This is true even with highly discriminating forensic techniques like DNA. If you know anything about DNA, you'll know about random match probabilities. The expert in a DNA case testify before the jury that this person's DNA matches the crime scene DNA, and the random match probability is 1 in a billion. When you tell people that it's 1 in a billion, what they hear is it's 1 in a billion against it not being him. That's not what it means. If the random match probability is 1 in a billion, and there are 7 billion people in the world, that means there are 7 people in the world with that profile. Or that's what you'd expect as a probabilistic extrapolation. The person who left the crime scene sample matches by physical biology, not by probabilistic calculation. So the actual probability that he is the donor is 1 over 8, an eighth, not 1 in a billion. Now you can see there's a huge difference between that. This, I can't go into the detail now because I'm out of time, but this kind of chart brings out these errors. This particular error that I've just mentioned to you, some of you might have heard this before, it actually has a name. It's called the prosecutor's fallacy in the literature. Prosecutor's fallacy, more technically, is transposing the conditional, and it is to confuse the probability of a random match if he wasn't the donor with the probability of innocence. Totally different things. By mapping it out, we can see where the argument goes wrong. And the argument is not maths. Even though we talk about 1 in a billion, it's not maths. It's not even science. It's logic. And Wigmore charts do logic. Okay, well, as you can see, we had a bit of some other things. I'm wrapping up now here. Modified Wigmorian analysis of the kind that I've been teaching is an effective practical tool. It's not a magical device that solves all inferential problems. It doesn't do anything more than systematize what's in your own head. So there's no, so some people are confused about this because they say, well, you know, where's the formalization for Wigmore? When people say that, they're basically Bayesian probabilists who have a mathematical formula, and they're saying, where's your formula? Haven't you just made it all up? There is no formalization in that sense. What Tillers used to say is, a Wigmore chart is a map of the mind, not a map of the world. And the mind involved is your mind. It follows that 2 people working on the same case will have different charts because it's my chart. The reason that you do it, though, is the same reason that, in essence, that you do long division on paper or on a computer or a calculator. You don't do long division in your head. If you try and do long division in your head, you make mistakes. Same with reasoning about facts. If you just try and do it all in your head by intuition, you'll cheat and you'll make mistakes. Are you able to hold 100 or 200 well-defined propositions in your mind and visualize all the relationships? I mean, some people can play chess without looking at the board, can't they? People can do this. Like people with circus tricks. Most people can't do that. So the Wigmore chart is not this kind of mysterious problem solver. It's a simple technique for projecting your thoughts onto paper and analyzing them and perfecting them. Simple as that. It's useful and it can be learned, and we've tried to teach it. So if you want to know more, this is something that we've done for the Royal Statistical Society, and the third report, the blue one, Logic of Forensic Proof, sets all of this out. It's about 100 pages long. It gives you, it's basically a primer on Wigmore, and it's free to download from the website. So I can't say fairer than that. And we'd be delighted to get feedback on it if anyone has a go and uses it and got questions. So I think I'll probably outstay my welcome. I'll stop there, Simon, and leave just a few minutes for any questions and comments. Thanks very much.
Well, thank you very much for that presentation. We have a few minutes for questions, comments. Who wants to begin? Yeah, Gladys.
Professor, I'd like to say that we should drag all the judges in to come and listen to you speak. But maybe you shouldn't be speaking at university at all. You should be looking to write this up as a course for kindergartens, because I think if we can teach our young people at the earliest age to start this kind of thinking and rationalizing and putting it down on a piece of paper, we might have a better society generally. So I think it's something that we could all do to improve. But I'd like to make a comment about how I think actually our systems are so concentrated on the justifying the system as it is, and all of the inbuilt obstacles to actually wanting to improve the system, and that, I'm afraid, does include the judges who are most set in their ways. You're going to have an awful uphill struggle unless you start at both ends and hope that they meet in the middle.
Do you want to say anything?
Thanks very much. I mean, look, I agree. This work is for judges and forensic scientists. It's not for law students. Yes, school kids could learn it, but it's never too late. Lawyers haven't learned it. You see, it's interesting. Most practitioners do something like Wigmore already. They tend to have devised their own systems for marshalling facts and figuring out what their best arguments are going to be. They have a version of it already. And this is just giving people an easy, ready-made version that they can use and adapt to their own purposes. So it's going on. But I think crucially, there is no choice in that whether or not the logic of forensic science is recognised, it's happening in court right now. So judges need to know this is not an option. That, you know, there are only two possibilities, knowledge or ignorance. The fact of the matter continues. And, you know, you say to people, yeah, education, it's costly in the sense that you have to invest time and resources. But if you think education is costly, try ignorance. Ignorance is really costly, particularly in something like criminal justice, where people pay with their liberty when miscarriages of justice happen because forensic scientists don't understand the logic. And the final thing, a lot of my time these days I spend with people in maths departments, believe it or not, because a rival version to Wigmore is Bayesian analysis, which some of you may know about. Now, if you want a hard sell, try and get judges to do Bayes. As soon as it involves numbers, then you've got a problem. The great thing about Wigmore charting is he invented it for lawyers. It's what we do. And my line to lawyers is always, forget the maths, forget the science, this is logic. We are supposed to be good at this, so let's get better at it.
So, Paul, can I just ask you two questions to better understand this approach? So you talk about approach for inferential reasoning. Does that mean that you cannot apply this to direct evidence? So it's only for cases that involve circumstantial evidence? That's the first question. The second question is, if it's about, and the way I've seen you used it here, about inferential reasoning, it helps you in identifying weaknesses in that reasoning process, gaps, reasoning, but it can't help you too much on the question of are you sure? Is that correct? It can't really help you very much on the standard of proof.
Good question, thank you. There is no such thing as direct evidence. Direct evidence is a lawyer's conversation. There are data. All there are dots in the world. Give me your example of direct.
The
direct evidence, in circumstance, one of the main differences is that with direct evidence, the crucial question tends to be the credibility of that witness and the reliability of their testimony.
So by direct you mean testimonial?
Testimony, yeah. But no, testimony, a witness could be testifying to circumstantial evidence. But direct evidence is someone, as I define it for my students, it's where the substance of the evidence is identical to the fact that you want to prove. Right? I saw him stab him. Right? So the issues, yeah.
So your paradigm you have in mind is the witness says, I saw him stab him. But if you were to try and chart that, there are probably 37 propositions in that. So, for example, one generalization would be, we have no reason to believe that this witness is in any way related to anybody in the case, or that they are in any way biased or partisan. Okay. That would be one. Okay. Another one would be something like, this is a person of average physical abilities. So if someone says, I saw him, he was 10 feet away, we believe them. If someone says, I saw him and it was a mile away, we don't believe them. Our question would then be, do you know what a mile is? Or are you mentally ill? Or, so every single inference has lots of assumptions built into it. The process helps us to bring those out. Now, there is the problem of the explosion of possibilities. Every single inference has a literally unlimited, infinite number of possible further inferences. So all the time we're using heuristics to figure out what we should be concentrating on, breaking it down. So that's dealing with the first point. The second point, you're absolutely right. And it's a crucial thing to understand, and I obviously ran out of time, but Wigmore shows you the logic of the inferential links between evidence and proof. It doesn't show you the weight of the inference. It doesn't model probative value. So if you imagine it, if you've got 10 different witnesses all testifying to fact X, that's 10 propositions all leading to one further inference. Now, visually, you might think, oh, that looks strong. But what if all the witnesses are rubbish? They've all got terrible credibility problems. They're all convicts or part of the same gang. A lawyer would instantly know that that testimony is problematic. So this is definitely a limitation. It can't model probative value. It can only model logic.
Does Bayesian model probative?
Well, you see, here's when it gets really interesting, because they think they do. And basically, by and large, lawyers think they don't. And this is partly a terminological misunderstanding, but it's not only terminological, it goes much deeper. And I can encapsulate like this. From a probabilistic perspective, there is such a thing as weight of evidence. You rationally analyse what you know, and you can then put some kind of probability on it. By the way, probability, conceptually, is not just numbers. You can have qualitative judgments of probability. So when we say something is likely or very likely or somewhat likely, that's probability, even though it has no numbers on it. So we can do that. The problem is, that's not what lawyers mean by probative value. Generally speaking, when we say about probative value, we refer it to the weight we think a jury will give to this piece of evidence in this particular case, in the light of all the other evidence in the case. So just a very clear example of this. So if you take DNA in a rape case, for a probabilist, this has great weight of evidence, a DNA sample. But a lawyer might say it hardly has any probative value. Why? Because my client is admitted intercourse. So you don't need to prove identity. It's all about consent. So that's a nice example of where scientist or probabilist says this weight of evidence is X, and lawyer says, no, it's not. And that conversation is going on day in, day out, and they're not even, there's no meeting of minds, talking past one another. So if you have our jury system, English jury system, I know you don't, but those countries that do, you are committed to some notion of a jury will know sure or proof beyond reasonable doubt. And there's nothing more to be said, theoretically, on that point. But it's interesting that in countries where they have professional fact-finders, like here, particularly in civilian jurisdictions, take the Netherlands, right now, forensic scientists are teaching Dutch judges to use Bayesian networks to decide cases. They've gone that far in using these kind of formal models in actual real casework. Now, there's all kinds of reasons why that would be both impossible and undesirable in England and Wales, and I'm not recommending for us or for you, but you can see for them it makes sense. If you're committed to rationalism in evidence, and if Bayes is rational, what more do you need to know?
Any more questions? Rob.
Can I just ask, because I'm sure you've thought this through, but when you've got the thing with the forensic science and you say now there's a 1 in 8 chance that this person from the DNA is doing it, well then obviously, what I would think of to look for next would be the corroboration. So because the corroboration will change those figures. So how would you put the corroboration into your sort of formulation?
Well, the 1 in 8 hypothetical that I gave is just a hypothetical. If you think that actually models the evidence, that's known as the defense attorney's fallacy. The reason being, of course, that in a criminal trial, the accused was not just picked at random from any person in the world. If they had been, then it would be 1 in 8. You talked about corroboration. Lawyers are always nervous about that because the technical meaning of corroboration. But if we can just say, because I think this is correct me if I'm wrong, but I think really what you're drawing attention to is other evidence, supporting evidence, right? Whether or not it's technically corroboration in the legal sense. Of course, it's always crucial. Evidence comes in webs of evidence. Go back to the dots. When we connect the dots, we don't necessarily just connect them in a linear way. We can connect them in all kinds of complex ways. You can have 4 dots going into 1 dot, and then 1 dot going into 6 others, and it's complicated. It's not a question of me fitting it into my model or Wigmore fitnesses or anything like that. Step away from that. The world is just complicated and full of dots, in my metaphor. What we're trying to do is make the best sense of it. A Wigmore chart can have any number of propositions. The question is, how long have you got? One of the great objections to Wigmore, for those who've ever looked at it, has been, well, it would take you a month to do a proper chart of a whole case. What lawyer has got a month to work on the whole case? It's not going to happen, is it? Unless it's very well-funded civil litigation, but generally not in crime anyway. The answer is that you use just as many propositions as you need to explore the points that you're interested in the time that you've got. A little bit of rationality is better than none. More rationality would be even better, and if the world were perfect, we'd all be Wigmorians. So that is that. And I think that the contrast with Bayes, although I've not really been able to go into that today, is instructive. Because the Bayesians, they want to say they've got the logic and you better do it this way. I'm summarising and rounding off some complexity, but that's basically their position. They're basically saying it's this or you're irrational. That's their position. I'm saying nothing like that. I'm saying here is a handy tool that you may well be able to use for certain activities in investigation, evidence marshalling, evidence analysis, preparing for court. It's a tool that can be used for all of these things, and I believe, and I've tried to give some examples, that it works, and that you can learn it pretty quickly. The one thing I'd just make this one. One of the difficulties in getting this over, and I'm a case in point here, you can't do this just by hearing about it. It's not something that you can, you can't have a cognitive recognition of it. It's a bit like having a lecture on playing the violin and then saying, well, now I can play the violin. Or having a lecture on driving a car and saying, right, now I'm off to drive a car. You only know what it means when you've had a go. And so you might think that's a kind of unfair point. I'm saying you won't really know what I'm talking about until you've given it a go, and my point is give it a go. But it is true, and really for 10 years with William, I was always a bit of a skeptic because I hadn't really tried it. And it's only when I actually tried it that I thought, well, actually, this is quite interesting, and I'm learning more about the case now. Turns out, you know, surprise, surprise, he was right all along, as was Wigmore. Thanks.
Right. Any more questions? All right, so it comes down to closing off today's seminar, which I think has been most, enlightening and interesting. I think you have taught us a lot, and given that we have just recently celebrated Teachers' Day in Hong Kong, I want to give you a token of appreciation. This is a stamp pack that the Hong Kong Post Office has put together as a tribute to teachers. So I'd like to give this to you, Professor Roberts.
Thank you very much indeed. Thank you.
So, thank you. And later this evening, we happen to have another criminal justice seminar with a professor from the United States, Professor Robert Klonoff. So if you're interested, come back at 6:30 or 7, I forget. It's on the 7th floor. 6 to 7, thank you. 7 o'clock. Or sorry, 6 o'clock on the 7th floor.